Hello, and thank you for listening.
Of course, Jennifer Pratt, one of our partners here at PraDa Law.
Hello, thank you for having me.
And our very special guest, Daniel Silver, joining us today with Family Law.
Pleasure to be here. Thank you for having me.
Ladies and gentlemen, the number is on your screen. We're ready to take your calls. The number is 888-88-LEGAL. Give us a call. We want to hear your questions. Here's a little more information. Take it away, Jennifer.
That's right. And on today's show, we have so much information to share with everyone. We have Attorney Silver, who's going to be talking to us about the latest information regarding family cases, especially during this COVID crisis that's going on. What's happening? Are you having issues with time sharing? Are you having issues with your spouse? Are you having issues with the education of your children? So many questions that are coming up in today's society, no matter where you are in the country, and quite frankly, even the world. COVID has affected us all, particularly in our homes, particularly with our families. And also today, we're going to be talking about bankruptcy. Right now, a lot of people have a lot of debt, have a lot of things that they're not sure how to restructure or what they can do. Bankruptcy is an option. And of course, I'd love to speak about the intersection, because sometimes there is, between bankruptcy and family law. I want to start today's show talking a little bit with Attorney Silver about family law and the state of family law right now during this COVID pandemic. A lot of things we're seeing in our office is that we're seeing parents that are struggling with time sharing due to COVID. It seems as though yet another excuse between parents is COVID. Whether or not on your time sharing, that means on the time that you have your children, whether it's via court order or oral agreement, the parent is allegedly taking the child to places where they are allegedly not adhering to social distancing, perhaps not wearing masks, and the other parent is raising these issues and these concerns, but more so to create issues in the case. How are we handling these cases, Attorney Silver? What is your recommendation to a parent who is struggling with this, and especially who is dealing with, and I know this is a compound question here, bear with me, counselor, especially who's dealing with, for example, a parent who is refusing to give the child or children to the other parent with the excuse of COVID-19. What do the administrative orders say? What is going on? Share with us your knowledge, Attorney Silver.
Sure, thank you. And I waive my objection to your compound question. So, first and foremost, I want to talk about two different categories of cases. One, a case where people have already been divorced, or a paternity case where there's a final judgment of paternity entered, and a time-sharing schedule. If there's already a court-ordered time-sharing schedule in Broward County and Miami-Dade County, there are administrative orders providing that that time-sharing schedule should be followed. However, are parents strictly adhering to the time-sharing schedule? What if one parent is a nurse or works in a hospital or has been exposed to COVID? Or what if one parent is not respecting social distancing and one parent is withholding time-sharing? If that's the case, motions in regard to this administrative order can be filed in order to obtain court intervention. Court is going on, court is in session, it's via Zoom, everything is teleconferencing via Zoom technology. So if you have an attorney, you want to make sure that that attorney is very knowledgeable and experienced with Zoom, screen sharing, the administrative procedures for admitting evidence prior to a hearing. And then you have a whole separate category of cases where parents may have just split up, or people who have had a child have been separated, and there's no court order. And maybe one of those parents is a nurse, or one of those parents has some sort of job where they're being exposed to the COVID, and the other parent is objecting. If there's no court order and no time-sharing schedule, and one parent is perhaps doing something in the child's best interest, not in the child's best interest regarding COVID, well, then that might be the grounds to file a case now.
Thank you, Attorney Silver. Once again, the number's on your screen, 888-88-LEGAL. We want to hear from you. We want to represent you. We want to find out a little bit more about what you're going through so that we know how to help you.
That's right, and remember that the first consultation is always free. Attorney Silver, I want to break this down for people, because right now, if I have a child and I know that you are going off to parties, gatherings, are you saying that these administrative orders are saying that I must still give you my child, and potentially you put my child at risk of contracting COVID or any other fatal disease or virus?
Well, first and foremost, if we have a child, the child is our child and not my child. And that's something to remember in family court if you want to make a good impression on a judge, because I've seen it personally when both parents say, my child, my child, my child, my child, and the judge hears it for hours on end. At the end of the hearing, the judge will say, ma'am, that's not my child, that's not your child, it's our child. So first off, if we have a child together, it's our child. Next, what are we seeing with children's issues with COVID when one parent is withholding time sharing or not adhering to time sharing schedules? You have to have court intervention in these type of situations, especially if you don't have any sort of order or agreement that's been ratified by a court in regard to time sharing and parental responsibility.
And Attorney Garcia, I know that you don't handle family cases at our office, but I know you're a parent, and I know this is relevant to you. You have children. I mean, just from a parental perspective, what are your thoughts? And I know you're in a, fortunately, very happy marriage, but what are your thoughts as a parent? Like, how scary is it to know that I have to give our child to the other side, and that potentially that the child or children can be exposed?
It's very, very concerning. I mean, especially if individuals are not practicing the proper social distancing recommendations and guidelines, whatever we're calling them these days, you know, whatever they are. That's really hard. And, you know, I see that with schooling now, you know, getting back into school and things like that. And, you know, as a mama bear, you just want to do what's best for the kids. And if you have an irresponsible partner, but you need to remember it's the partner you selected, and, you know, you guys have to come together to attempt to come to an amicable agreement at that point. No.
Thank you so much, Attorney Garcia. Yes, a lot of very informative information that you guys need to know that we can help you with. The number's on the screen, 888-88-LEGAL. Very simple. Just give us a call. The consultation is free. We have people around the United States ready to help you, attorneys ready to help you. Again, the number is 888-88-LEGAL.
And that's right. I mean, at the end of the day, we can't undo whatever partner you selected, but we can certainly help you navigate through the legal system, and we can certainly help you with what the court is most interested in. And a lot of times we have clients come to our office and they'll say, me, not just in the context of my child, but also me. And it's important to note that when there are children involved, Attorney Silver, does the court care about me or you, or who is it that the best interest they're really interested in?
Well, look, the court is going to care about the parties, but the court is going to be far more concerned with the best interests of the minor child. The family law foundation in Florida statutes and shared parental responsibility is all based upon the best interests of the minor child. A court is going to make decisions in the best interest of the minor child and not in the best interest of one of the parents. The parent's interest should not trump the child's interest. The child's interest should be first, foremost, and paramount to any parenting plan or any court ruling regarding time sharing of a minor child.
Absolutely. Thank you so much. Once again, Attorney Silver. We're here to help. We need your calls, 888-88-LEGAL. That's the way we're going to be able to help you figure out your situation in family law.
That's right, and whether it's family law, bankruptcy, we're here today. We have expert attorneys that are going to be talking to you about all sorts of laws, including family and bankruptcy. Now, when we say the word expert, we have to be careful with that word. As some of you may or may not know, there's a difference degree as to whether or not an attorney is an expert. And what I can say about the attorneys on this panel is that whether or not they're experts is for someone else to decide on another day. But I will tell you this, they are seasoned veteran attorneys, both with over 10 years of experience. Attorney Silver has been an attorney for nearly 17 years, and Attorney Garcia has been an attorney for 11 years and counting. These are folks that were not, you know, they didn't graduate just yesterday. They know the law. They've been practicing in their area, and experience does make a huge difference. And I want to come back from the break and talk to both of these attorneys about how their experience has made a difference in one or two of their cases. So stay tuned with us. We have a lot of information, a lot of solutions as well if you're dealing with family issues right now or bankruptcy issues. And we also want to talk about the intersection between the two. So the number's on the screen. Join, participate. The consultation's free, 888-88-LEGAL, and we'll be right back.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
Hello, and welcome back to PraDa Law Live. Once again, I'm Jackie Mendez, your host for today's show. We have an excellent panel. Daniel Silver joining us today with family law. Again, we're talking bankruptcy. We're talking a bunch of things that you need to know so you know your rights and you can stay protected. The number's on the screen, 888-88-LEGAL. It's easy. It's a free consultation. Give us a call. We want to hear from you.
And today we're talking to Attorney Silver about family issues and Attorney Garcia about bankruptcy issues. And before the break, we were talking heavily about family law and some of the issues that have come up with COVID-19. Another thing that we're seeing a lot in the office is folks divorcing. Unfortunately, COVID-19, or fortunately, depending on who you ask, COVID-19 has spared a lot of divorces. And on the same token, I also recognize that this time at home, quarantined, has also solidified and made stronger a lot of relationships. But for those of you who have found yourselves in the brink of divorce, this is a time where you need guidance. Don't allow anyone to convince you that you do not need an attorney for a divorce. Because when you make that bad decision, you're going to come to me later and ask me to try to fix things. And I may or may not. It's best for you to have an attorney now so that all your rights and assets and liabilities and everything are properly sought out in that divorce. Now, quickly, a lot of people think I'm getting divorced, I'm going to take him or her for half of everything. But half of everything also means half of the debt. Isn't that right, Attorney Silver? Doesn't the good also come with some bad in some cases?
Absolutely. You know, there's an exception to every rule, but generally speaking, when two people get married, two become one. So every dollar that is earned by either party is a marital asset, and every dollar that's borrowed by either party is a marital debt. However, the exception to the rule is if one party goes to Las Vegas and blows a bunch of money on alcohol and gambling and basically dissipates marital funds. That would not be a marital obligation. That would be a non-marital obligation, and that would be dissipation of the marital estate. One point you made that was very interesting, you said about fixing things. Now, if an opposing party tells you they're getting divorced and you ask them, do I need a lawyer? You might as well be asking the barber if you need a haircut. And if you enter into a bad agreement and you have a bad final judgment entered and you come to our office with a whole bad mess of a case, it's going to be twice as expensive, take twice as long, and be twice as difficult to fix. If you come to us with a clean slate, we can guide you, we can come up with a plan, we can come up with a strategy, and we can protect your interests.
And you know, we've had cases where folks got divorced, whether on their own or with the help of what they refer to sometimes as a notary or a mediator. And, you know, look, at the end of the day, if you and your partner, you and your spouse are able to come up with an amicable mutual agreement, that's great. But the reality is that oftentimes very important details are missed in these deals. And when you come to us later on, I'm not saying it's impossible, but it certainly does create more difficulty in trying to fix these issues that were created by you not just obtaining an attorney from the get-go.
That's the same token in bankruptcy. If you file pro se, you know, file a bankruptcy on your own, or you use an attorney who just dabbles, well, you know, they'll file a bankruptcy today. You run the risk of getting stuck in an improperly filed bankruptcy, for example, a Chapter 7, when you should have been a 13, and now you can't just walk away from a Chapter 7 bankruptcy filing. You are stuck in a 7. You'll have trustee coming after assets if you didn't properly protect them, and you can't just say, you know what, I don't want to do this anymore, I'll just deal with my creditors. At that point, it may be too late, and that's why it's so important to you know, be proactive and go with an attorney who does bankruptcy. That's in our practice at PraDa Law. That's what I do. I don't do any other cases, you know, maybe some loan mods, but you know, I do bankruptcy. So I will make sure that I put you in the proper chapter.
And you do loan mods, but there's loan mods
in bankruptcy,
exactly, as well. Exactly, the MMM program, correct?
Correct.
Talk to us about that. What is the MMM program?
Well, the MMM program is a way to save your home in the bankruptcy. It's fantastic now. It's great in this time, especially in our financial show. You know, we discuss how 45% of certain lenders' profiles are in default of their mortgages. You know, in a bankruptcy, you can use the bankruptcy to become current on your mortgage through the MMM process, where you apply for loan modification, but under the regulations and the eyes of the federal court.
Thank you so much, Attorney Garcia. Definitely be proactive and call the number on your screen, 888-8-LEGAL, 888-88-LEGAL. We're willing and ready to help you. We have attorneys at law ready to help, ready to hear you, to answer your questions.
And as much as bankruptcy may be a great tool for a lot of folks out there, one of the things and one of the ways in which family law intersects is because certain things in bankruptcy are just not dischargeable. Attorney Garcia,
Right.
What are some of those things related to family law that are just not dischargeable in bankruptcy?
Alimony, child support, those are obligations that you have to continue to pay. You cannot walk into a Chapter 7 and say, I'm lumping in my ex-wife with Bank of America. You know, it's just not going to happen. She's a separate claim and you're going to pay her. I can't, or him, you know, either way. I can help you, though, in a Chapter 13 become current on your obligation, because if you have fallen behind, it's not like falling behind on a credit card. You know, you can be held in contempt in family law, and I think Attorney Silver has, you know, explained that to us before, but you can use the bankruptcy to become current on these obligations.
That's right, and we're coming up soon on the commercial break, but Attorney Silver, briefly, could you tell us how it is that if I stop paying alimony or stop paying child support, what does it mean to be held in contempt, and what could I be facing if I don't pay these obligations without properly petitioning the court first?
If you have an existing child support or alimony obligation and you are not paying that obligation, you can be held in contempt of court. And if the court finds that your contempt is willful and intentional, and you have the money either in a retirement account or a bank account or other sorts of liquid funds and you're just not paying, court has a jurisdiction to throw you in jail. However, in Florida, the contemptor will have the keys to his own jail cell, so if you have that money and you access that money, usually you can pay a purge and relieve yourself of the contempt. But regardless, you don't want to find yourself in that kind of situation. If you've lost your job, if you have an alimony or a child support obligation and you are not making the money that you were making at the time of that order, then now's the time to give us a call to talk about a petition for modification, so you can reduce that support obligation and not find yourself in contempt of court, especially if you filed the petition for modification before they filed the motion for contempt. Then your petition for modification needs to be heard first.
Thank you, Daniel. Again, don't hesitate. Don't wait. We're here to help you. The number's on the screen. It's easy. It's simple. The consultation is free, ladies and gentlemen. Give us a call, 888-88-LEGAL. We're here to help. We want to hear you. Jennifer?
And that's right, and we're going to go to a quick commercial break, but before we do so, I want to remind the audience that the first consultation is free. The number's on the screen. As Jackie says, give us a call, whatever legal question you may have, ranging from bankruptcy to family law. Our law firm has attorneys that are working these cases, that this is what they do day in and day out, and they're here to help you. So give us a call. Don't hesitate. We'll be right back. We're going to be talking furthermore about the intersection between bankruptcy and family law. Call us. Let us know what's on your mind.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo? ¿Cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
Welcome back to PraDa Law Live. I'm Jackie Mendez, your host, and today's guest, Daniel Silver, is here talking to us about family law. The number's on the screen, ladies and gentlemen. 888-88-LEGAL. The consultation is free. We want to hear what your issues are. We want to be able to help you. Jennifer's here to lead us in to our last segment.
Thank you, Jackie. And before the break, we were talking about the intersection between family law and bankruptcy. And I also promised you that we would talk briefly about experience, how experience makes a difference. So I'll start briefly, and it actually coincidentally happened today. I went to court, and there was a prosecutor, a government attorney, that was attempting to convince me that our hearing today was not going to go forward. The hearing was on a bond motion for a detained person inside an immigration detention center. The prosecutor or government attorney really tried to convince me that this hearing was not going to go forward, and basically was a little bit shocked when I stayed around. And I think she was kind of baffled, like, why are you still here? I think that if I had been an inexperienced attorney or lacked the experience that I have, that any other attorney, because she was very demanding, very commanding, like very confident and sure of her position that my motion for bond today was not going to be heard, any other attorney would have left and would have unfortunately had to call their client and said, sorry, your hearing didn't go forward. But I stayed, and that really shocked her, I could tell. And I stayed, and I had my motion heard, and my client lived another day, and we have court again to have these issues reheard again. But I didn't get a denial, and I certainly didn't leave with my tail between my legs. And I think that's what she was expecting. And I want to touch on that today because I truly believe that experience does make a difference, particularly in the legal world. And Attorney Silver, we were talking before the break, if you could just give us an example of a time in your almost 17 years of legal experience where your experience truly made a difference in a case.
I can think of two. First off, before I started practicing family law in 2008, for the first 5 years of my practice, I did nothing but criminal defense. And criminal defense educated me on the rules of evidence. And in family court, there's a lot of emails and text messages and videos and third-party hearsay and child hearsay. And if an attorney doesn't know the rules of evidence, they're not going to be able to take the evidence that you have and get it properly admitted into court, which is going to prejudice your case. The other experience that I have is because I've been handling family cases for going on 12 years now. I've had a lot of cases, a lot of high-value cases, and I am a lawyer. I am not an accountant. I give legal advice. I do not give tax advice. However, I can see cases where there are capital gains in real estate, sales of retirement accounts or sales of stock. There may be real estate issues. There may be all sorts of retirement issues or alimony issues. And regardless, I'm going to know when a tax professional is needed, because if that tax professional can save you money by saving you from paying the IRS legitimately, well, that's something that the tax attorney, or rather the forensic accountant, can take advantage of, and we can bring him in to assist.
Attorney Silver, two things before I move on to Attorney Garcia. A lot of folks say, but my kids will come testify. My minor children, my 8-year-old, my 12-year-old, my 10-year-old. Are judges inclined to allow children to testify in these family matters?
Absolutely not. And there's a rule that says if you are going to have a child come to court, you need to have that court's permission in filing a motion in advance. Usually, if a child has something to say, you need to have a guardian ad litem or a social investigator or some third party appointed by the court, because it will have a detrimental effect on a child to either be brought to testify or brought to chambers to testify before a judge. It's not a good experience, and it's not something that's going to serve the best interests of a minor child in a divorce case. But given if you've got a 15, a 16, a 17-year-old child, well, that's a young adult, and perhaps that child might be able to testify and give the preference, just depending on what the allegations are.
And two, you're saying that I can't just show up to court with the text messages? I mean, they're on my phone. Like, you text me this, I can't just show the judge?
Well, in text messages, sometimes there may be a problem with the chronology, but typically if your spouse sends you a text message, that will be admissible. But when we admit text messages, usually we're not just going to bring the phone, we're going to download an app, we're going to print all the text messages in a chronological order, have them provided to the other side, and in a format where they will be admissible, because you can't just hand your clerk your cell phone and expect them to download the text messages. The problem comes more often when you have text messages from a grandma or a sister or an aunt or just some friend or a third party that may not be there to testify in person.
Thank you, Daniel. Again, we have seasoned attorneys ready to help you. The number's on the screen, 888-88-LEGAL. Give us a call. We want to hear about it. We want to know what your concerns are. We want to be able to help you.
And I can't believe that this show is almost over. Production is telling us we have under 3 minutes, but I cannot leave the show without hearing from Attorney Garcia. What is a situation or even just general statement like Mr. Silver made about how experience in bankruptcy? You know, one of the things you said earlier that's really important, because I know with the COVID-19, I know it, you know it, we both know it. There's a lot of attorneys that have never stepped foot inside a bankruptcy court in their life, don't know the difference between a Chapter 7 and a Chapter 13, much less a Subchapter 5 or 11, and are filing bankruptcies for people, not knowing that folks can go to jail if they don't file their bankruptcy correctly. Hello, Real Housewives. Hello, has anybody heard of that? So tell us briefly, because I know we're under 2 minutes here, a moment or just generally where your experience has played, you know, an effective role.
Sure. Generally, for example, I had a client a couple years back, and he's still a pending case of mine, where I filed his 5th bankruptcy because he had been not through any fault of his own. He had gone through attorneys who just consistently did not help him and gave him bad advice, and he almost lost his house. And I was able to get him a loan modification over the objections of the bank for being in the bankruptcy, and I was able to help him, but I was his 5th attorney because he was improperly advised. Also, bankruptcy has a lot of local rules, a lot that change from district to district. So if you're not seasoned in your district, did you properly serve it? Did you get that certificate of service up on time? These are all things that a practitioner who's in the trenches all the time will know and will understand, and that's what we bring to the table here at PraDa Law for you.
And not to get technical, but about the local rules, I remember that once I had a case where there was a difference between asking for a 2004 examination. Either you can just get it, you can just file the notice, and in some jurisdictions here in the state of Florida, you have to file a motion and get an order from the judge to get the opportunity to do a 2004 examination. Don't worry, on the next show we'll explain what 2004 examination is.
Ladies and gentlemen, thank you so very much for joining us today. PraDa Law Live. I'm Jackie Mendez. Daniel Silver, thank you so much for joining us. Attorney Garcia, Attorney Pratt, we hope you guys have an excellent rest of your day. Thank you.
That's right. I'm so happy to have had all of you here today. If you have any questions, remember the number to call is on the screen. The consultation is free. You want to meet with Attorney Silver, you want to meet with Attorney Garcia, you want to meet with myself, we are here Call us now. The number's on the screen, 888-88-LEGAL. Thank you so much. Have a wonderful day.